Item 2, public hearing, public comment. Citizens who desire to address the City Council Board and/or Commission with regard to matters on the agenda must complete a request to speak form and give it to the City Secretary or designee prior to the beginning of the meeting. Each speaker is limited to 3 minutes. Speakers requiring a translator will have 6 minutes regardless of the number of agenda items to be addressed. Comments or discussion by the City Council, Board, and/or Commission members will only be made at the time the subject is scheduled for consideration. Has anyone submitted public comments?
Not for the public comment portion, but for the public hearing, yes.
Okay. Item 3, minutes. Consideration of an action on the minutes of the November 19, 2025 meeting. Does anyone have any corrections? No? Okay, then can I have a motion?
Motion to approve?
I have a motion from Mr. James. We have a second.
I second.
Second from Mr. Morton. Can we take a vote? Oh, just by hand? Okay, so if you approve the motion, raise your hand. Okay, the motion passes unanimously. Okay, item 4, public hearing. Item 4A, public hearing, receive and hear all persons desiring to be heard regarding a proposed special exception to the rear yard setback for 77 Greensward Lane, Lot 12, Block 10, Sweetwater, Section 1, in the restricted single-family residential R-1R zoning district.
Good evening, Board. So I am clearly not Lucas Corbett, but I will be presenting on his behalf this evening since he is not with us. But with that being said, we will go ahead and get into the case before us this evening. So the property located at 77 Greensward Lane was platted as Sweetwater Section 1, and this was done in 1981. The property was then subsequently annexed into the City of Sugar Land in 1997, and at that time, R1R zoning was applied to the property. The applicant is requesting a rear yard special exception for proposed single-family new construction. And then a little bit of the case overview. So the recorded restriction for the property establishes a 5-foot rear yard utility easement, whereas R1R zoning requires a 30-foot rear yard setback. The proposed single-family residence would align with the recorded restriction and would be located approximately 5 feet from the rear property line. The special exception would relieve the 30-foot R1R rear yard setback requirement and would allow for the single-family residence to be constructed as proposed. And then this is going to be the proposed site plan for the new construction. So this is going to be the lot delineated with a solid black line. Those are going to be the bounds of the property. This is going to be the proposed new construction, residential. And then this is going to be the part of the property that the special exception is before you. And this is going to be where the property is sitting about 5 feet off from that property line. Again, this is in accordance with the recorded restrictions for the property. And then these are going to be the proposed front and rear elevations for the project. And then these are going to be the side elevations for the project. And then this is also going to be an aerial view of the property with the property located at 77 Greenwood Lane delineated with the red arrow. Which brings us to the neighborhood analysis for the property. So staff has examined the project and it appears to be architecturally compatible with the existing neighborhood. There are approximately 18 nearby homes within the nearby vicinity that do not meet the rear yard setback requirement of 30 feet as established by the R1R zoning district. And there are approximately 3 nearby homes that have an approved special exception for the rear yard, with one of these properties being the property that abuts the rear yard of this property. Which brings us to the special exception criteria. Number 1, was the property platted prior to annexation? Yes. Number 2, is the recorded restriction less restrictive than the setback that's established via zoning? Yes. Number 3, is a special exception not less restrictive than the recorded restriction? Yes. And then the 4th criteria, is the proposed project detrimental to public health or injurious to the neighborhood? Staff sees no apparent issues with this request. And then public hearing notification requirements were met for this case. Mailers were sent out to property owners within 200 feet of the subject property. There was a public hearing notice published in the newspaper and on the city's website, and there was also a courtesy sign that was placed on the property. At the time of creating this PowerPoint, there were 3 inquiries that had been received at this time pertaining to this special exception. 1 was on opposition, and then there were 2 general inquiries pertaining to the project. And then at this time, staff recommends the approval of the special exception with the condition that the proposed single-family residence is constructed in accordance with the attached site plans and elevations provided. Oops. And then any questions? I am here, and then also the builder for the applicant is here as well to answer.
Okay. Now open the public hearing. Citizens who desire to address the board with regard to matters pertaining to the public hearing will be received at this time.
First up is Uday Mahagor Akar. Yeah, that's me. Okay, hopefully I said it accurately. So come to the podium and state your name for the public record.
Hello, my name is Uday Mahagaonkar.
Okay, hold on, I need to swear you in.
Sorry?
I need to swear you in,
Okay.
okay? Do you solemnly swear to or affirm to tell the truth in these proceedings under the penalty of perjury?
Yes, I do.
Proceed.
Okay, so I live on 33 Greensward Lane, and what I'd like to point out is some of the experiences that we've had with a very similar house right next to us, which was 29 Greensward. Basically, that house also had similar variances. And essentially, one of the big things is a fire hazard. It's a huge fire hazard when you allow this kind of a 5-foot setback. And I don't say that just because it's a theoretical possibility. A fire occurred. The house next to us burned down completely to the ground. We were in our house where we are still today. And the fire chief said that they had a tremendous difficulty in trying to contain the flames in terms of reaching our house. They managed to do it, but that was because of the old house being further away from our house. With the new house being so close by, it's going to be extremely difficult for the fire department to contain the flames to the neighboring house. So that's a big, big hazard that I want to bring up. And that was never addressed before by the city or by the FCCSA. Secondly, privacy. When you build such a big house with hardly any setback, there is tremendous impact on privacy. In my house, with the new house next to me, the windows, they just look right into my kitchen. I would have to seal off all my windows in order to get the privacy. And so that's a huge thing that has never been taken into consideration because you don't live there. You don't know how it is. Thirdly, Sweetwater is a neighborhood which has open spacing, big lots, houses far away from each other, and if you try to squeeze them in, which like they've done in 29 Greensward and is supposedly going to be done with this new house on 77 Greensward, you are going to lose the open spacing requirement. And it's the entire architectural beauty of the neighborhood is going to be destroyed. So I seriously saying that this should not be allowed. It's going to create these major problems. Now I have some other colleagues here and neighbor friends who are going to talk about drainage issues as well. Any comments, any questions to me?
There we are. Where is your home located relative to this property?
Just behind it, sort of diagonally behind it. So the corner.
The address was 33, correct?
Yes,
So you have a pool against your back fence,
that is correct.
and then, okay, so it's this.
Got it.
It's this one here.
Thank you, sir.
Okay.
And then 29, which is next, that's a vacant lot, is that right? Or is that a house with,
That's the house that was burned down, and then they built this big house.
okay, it's just got a tan roof, so it looked like it was a mound of dirt.
One additional question for you, sir. Just a point of clarification. Were you the party who had lodged an objection with the city that our city planner mentioned earlier? Had you previously lodged a formal objection to this special exception earlier with the city?
Just last night I sent a form in, but not this is the first, because before that we didn't know whether this house was coming up. So,
Of course. Thank you, sir.
yeah.
So what was the answer? That's the same.
Follow-up question for you, of course. Please.
Sorry, so just kind of wanted to speak to that a little bit. So I am not the original case planner for this project. I do know that it was a gentleman. I do not know which gentleman that it was, but I know that the kind of complaint was prior to this week, so I would say that if his form was filed yesterday, it was most likely not that individual, but a different individual that had filed that.
Understood. Thank you so much.
If
I
I
have
could just
nothing
follow up maybe on that, just avoidance of, or for clarification, what was the nature of the objection that was received?
So I believe it was something to the effect of that the house was going to be too large and that it would kind of prevent privacy, that they would be able to kind of peer into the adjacent properties,
Okay, so,
from my understanding. Again, I was
privacy.
not the one that fielded that call. This was not originally my special exception case, but from my understanding, that was the original complaint.
okay. And that was not in the packet or anything, that just explained what the objection was?
So no, sir. So when the report was written, there had been no objection, but when the time that the PowerPoint was being
Right.
created, then that time we had received that. So at the time of creating the PowerPoint, those were kind of the comments that we had received from the public.
Okay, thank you.
I had a question.
Yes, sir. I'm
So,
sorry.
as part as criterion 4, you guys said you did a public safety review?
Correct.
So does that also include like fire hazards?
Fire, EMS, correct.
Okay.
Yes, sir.
All right.
Maybe to belabor that point, just a second. So in doing a high fire hazard review, the conclusion, the opinion of
Staff.
fire-trained people that it truly was not a hazard.
So yes, so we have standard setbacks that are 5 feet in our other zoning districts. We also have side yard setbacks that are 5 feet. That is standard. So implementing this 5 yard, or I don't know why I keep saying 5 yard, this 5 foot setback would not be injurious to health, safety, or welfare. There's also 18 other homes within the nearby vicinity that already don't meet that requirement. And there are also 3 approved special exceptions. And actually the property behind this one, it got a special exception approved for the exact same platted restriction. So there's a 10-foot utility easement that runs, and then it's split between the 2 properties, so it's 5 and 5. So the property behind them, so the property behind them had received a special exception for a rear yard setback following that same platted restriction. And there were no safety concerns, no fire, EMS concerns at that time as well. Yes, sir.
Chair,
Chair, I'm sorry. If you don't mind, if we could.
Thank you.
Many thanks.
next we have Gregory Owelski.
Yes, thank you very much. I'm a resident on
Oh,
Greenswood.
sorry, I just need to swear you in.
Gregory Ofke.
Okay, can you just raise your right hand? I'll swear you in. Do you solemnly swear or affirm to tell the truth in these proceedings under the penalty of perjury?
I do.
Okay, proceed. Thank you.
My residence is 82 Greenswood, which is right around the corner. This lot is basically not right across the street from me, but just sort of catty corner from me. Been a resident there for 40 years. My concern is that I know that the house at 29 behind 77 received a variance. My concern is now we're getting 2 houses stacked one behind the other that have a 5-foot variance. So that house has an area that's basically 5 feet from the fence. This house is going to be in a large portion 5 feet from the fence. There's could very easily be a drainage issue. I don't know what the elevation is going to be on the slab of the home. That could very easily force drainage issues with all the surrounding homes. Now I'd like to see a fireman back there saying, well, that house is 5 feet from the fence. This house is going to be 5 feet from the fence. We get a fire going here, this is going to be a major problem, major issue. And we know what can happen because the house that's directly behind 77, that's how that lot became available. It burned down. It had a fire. So I'm concerned about not having backyards that are starting to look like a townhome, 0 lot lines townhome. It's just basically you're talking about squeezing too big a house onto too small of a lot. And with me being a resident there for 40 years, there's a certain appearance that we've sort of become accustomed to of the houses not being just right on top of each other. You know, when you're looking out of the top floor of 29 Greensward into the house that's going to be built at 77 Greensward, I mean, I wouldn't say reaching distance, but it's not going to be much. It's not going to be much. And when you have a house of that size and you've got a backyard that you might be able to fit a grill over in one area, you're sure not going to be able to have a grill over in the 5-foot area behind the garage, but there's going to be home construction above that garage. So it just is very concerning from safety, from fire, from drainage, and just basic appearance and viewing, having privacy in your backyard that you're going to just sort of feel like you're in a fishbowl. Thank you.
Thank you. Is there anyone else, or?
Next, we have Lisa Gibson. And Chair, we have 2 more following Lisa.
Good evening.
Hi,
My
Ms.
name's-
Gibson, let me just swear you in. Do you solemnly swear to or affirm to tell the truth in these proceedings under the penalty of perjury?
I swear I'll tell the truth.
Thank you.
And this is my husband, John. We are residents at 17 Halfpenny Court, and you could probably see that on the plat. We got a copy of the staff documents so we could see the elevation of the house, and one of the things that was included in that were several overhead layouts of the lots and apparently some drone pictures of backyards. So I have 3 points. My first point is I'm going to echo very much what was previously said, that what makes Sweetwater special is the land around the homes. If you go to many of the other neighborhoods, it's a custom to see houses so close together that you could, pass a letter to the next door neighbor through an upper bedroom. That's how close some of the new neighborhoods are. What makes Sweetwater very unique and special is the size of the lot and the perimeter around the house and the mature trees. So I think that putting this house in is going to compromise the integrity, the space, nature of our properties, and I'm concerned about that. And I'm going to go into my second point, was learning from a bad experience. 29 Greens Ward is a tragedy in our neighborhood. This was how it got passed, how it got built. It's the 0 lot line that's backing up to the proposed new build. We are pretty consistent architecturally from that perspective. This house is an extraordinarily tall Mediterranean structure, which frankly I feel devalued the properties on either side. And coming out of Sweetwater, I have to look at this house every day, and I just shake my head and say, how did that get passed? And so, yes, the exemption was made, and this is a house that goes up nearly to the back fence. It's straight up 2-story, and it's a real eyesore for the neighborhood. And then lastly, I was looking at the documents for this case where 18 houses were circled in yellow, stating the precedents. Oh, the 30-foot setback doesn't apply, and the 5-foot. There are plenty of people that have gotten the 5-foot. But I will point out that many of those homes back up to the golf course. It's not home to home. And what we're dealing with right now are home to home, 5 feet apart. 10 feet in total. Not patios, not pools, but house to house, 10 feet apart. Can you imagine? It would be like the gentleman in the blue shirt and myself, we would be so much closer. And that's the physical structure of the house, not a pool deck.
I'm sorry, I believe your time is up. Thank you, ma'am. Thank you, ma'am.
Next, we have Desmond, it looks like Mills.
Hello.
Hi. Do you solemnly swear or affirm to tell the truth in these proceedings under the penalty of perjury?
I do.
Thank you.
Okay.
Proceed.
My name's Desmond Mills. We live at 81 Greensward. If you're facing the proposed build on 77 Greensward, we're the house immediately adjacent to the right of it. If you look at my home, so I have 4 concerns or complaints as it relates to the proposed bill. Number 1, as you heard, the issue with fire risk. As you already heard, the house on 29 Greenswood is right there, the major bill that it got the easement exemption already, really close to the other, and those two next to each other creates creates a major risk. And then if you think about the roof size of those two homes, both of those homes really big, within 10 feet of each other, and the water that comes off those roofs, how it will drain onto the adjacent properties, including mine, is a major concern. Likewise, if you look at the build of their home, the second floor of their home on this extra part will extend past the backyard of my home. So my pool, right, so it'll go to the lot line. My home ends nearly about 30 feet before the line. Theirs will go 5 feet above the line. So that's that back part of their home and the windows on it. I understand that there are 3 windows on their home and bedrooms that will overlook my backyard, overlook my swimming pool, and create complete a privacy issue as it relates to the back of my home. So completely changing the aesthetic of, one, the neighborhood, how the other houses all end kind of at the same point, and allow the others to have some yard without a house towering over it. And we already have on the back side of our homes where the houses come up to the back line. Even if it's 30 feet, those houses kind of overlook the yard of the people on the other side. Having the houses on side of you now go past that line of 30 feet really creates a privacy issue as it relates to the backyard of the adjacent homes. And lastly, I'd say when you look at the home, particularly in the backyard of the home, there are some utility lines, particularly like cable and internet lines that are in the backyard of 77 Greensward. And those utility lines right there, that cable line, is really within about 5 feet of the house also. I don't see how they're going to be able to get to those lines, to service those lines, with that house being so close right there. I have a utility box in my backyard, for example. I've had to have them come out during power outages and get equipment back there to move that in and out. And if there's any need to change those cable lines or get to them, they will not be able to get any machinery or equipment back there to get to it with the way that house is proposed to be built. So major objection to the home being built the way it's proposed. Thank you.
Thank you, sir.
And our final speaker is Grace Leo.
I'm Grace Liu.
Hi. Do you solemnly swear or affirm to tell the truth in these proceedings under the penalty of perjury?
Yes,
Thank you.
I write down all the things in case. I live in the Greensward, 70 Greensward. The house going to build just close to the street, I can see it. I live in the Greensward for over 25 years. I'm expressing my grave concern regarding the critical issue of maintaining separate distance for building fire safety related to this special exception request. My concern is rooted in my horrible memory of an arson occur at 29 Greensward, probably around 15 years ago. The fire was furious and fast moving. Fortunately, because the surrounding property has maintained adequate safety distance, the fire department was able to prevent the fire from spreading to the surrounding. I still remember that time. People crying, kids just shouting, and my neighbor called me, Grace, my mother-in-law and the 2 dogs inside the house, get them out. I still remember scale. So all the houses so close, if they building close, they will got trouble, okay? However, during the reconstruction of that site, the burning 29, and 4 years ago, the massive structure was built. That was completely out of proportion of the rest of our street. I call the house is a monster. Neighbor hate, everybody hate. I think people live there is feel probably they will wonder why people don't talk to them, okay? The building was squeezed out nearly all the safety buffer zone, creating persistently safety hazard for all our neighborhood. I do not want this mistake repeat. I earnestly urging the zoning board to exercise strict oversight on this future development project. People want to make money. We like a new builder. We like a new good neighbor, but not take advantage of this beautiful subdivision. I believe City of Sugar Land proud of Sweetwater Country Club, just like you live in the Houston River Oak area. And you represent our resident. It is important to ensure that every project maintain the legal safety distance required to protect.
Thank you, ma'am. Do we have any more speakers, or?
That concludes the speakers, Chair.
Okay, I now close the public hearing. We will now move forward with consideration of and action on the proposed special exception to the rear yard setback, 77 Greensward Lane, Lot 12, Block 10, Sweetwater, Section 1 in the restricted single-family residential R-1R zoning district. We can ask questions. Yeah, I think we can, when we get to number 4, right? Yeah. First criteria, the latest recorded plat of the property was approved prior to being annexed into the city. Do we agree that the plat was recorded prior to being annexed? Yes. Okay. Second criteria, the latest recorded plat or other recorded restriction for the property establishes a setback or other regulation that results in a setback that is less restrictive than the setback required by the City of Sugar Land Development Code, Chapter 2. Do we agree that the recorded restrictions are less restrictive than those established by the City of Sugar Land Development Code? Yes. Okay. Third criteria, granting the special exception will not establish a setback that is less restrictive than the setback established by the latest approved plat or other recorded restriction. Do we agree that the proposed special exception is not less restrictive than the recorded restriction? Yes. Okay. So fourth criteria, granting the special exception will not be detrimental to the public welfare or injurious to the property or improvements in the district or neighborhood in which the property is located. Okay. I believe we have some questions. Go ahead, you can go, Mr. Moore.
So I wonder if it would be helpful to bring up,
The site plan, perchance?
sorry?
Maybe like the site plan, the overall? For the
Well, I was gonna first maybe give up the Google view, whichever this one is.
Ooh, biscuits.
That's got all the yellow squares and red squares and blue squares, and
Yes. 1 moment.
just so we're all kind of looking at the same thing and talking about the same thing.
Sorry, technical difficulties.
Okay. Yeah, so if you're following along at home, hopefully you've got a bigger version. Okay, so we heard from, is there a bigger version of that? So in red is 77, and we heard from several, go ahead. I'm sorry to put you on the PowerPoint Ranger challenge.
Okay, there is not a way to zoom in.
Okay, all right.
Sorry.
So the red one is, it sounds like people have copies of this anyway. So the red was the property at question. Has that been vacant the whole time?
For the course of this special exception, yes.
Okay, so was it vacant when the fire happened, in 29?
That I would not be able to speak to.
I'm sorry?
That I would not be able to speak to.
Okay, I saw some, so there has been a house on 77 before?
Yes.
And it's been raised? Yes. But that had nothing to do with the fire?
No.
Was it, was there a house there when the fire occurred?
Yes.
Okay, so clarify, okay. Noted, okay.
The house that burned and the house behind it both had the 30-foot
I'm sorry.
setback and that.
I'm sorry, can you come up and,
Well, it needs to be between staff and.
oh, I see.
Okay, so, okay, sorry. All right, so I guess the question is, the house that was on 77, what type of setback did it have at the time of the fire, so that at least the fire responders were able to save 77, 73, 33, 25, 81, all the ones around 29.
So that I would not be able to speak to, but from the presentations given by the kind of community, it seems like that was maybe about 15-ish years ago. So I wouldn't be able to really speak to that.
So we don't know.
Correct.
Okay, so we don't
But
know.
with that being said, the property, was platted in 1981. It was annexed in 1997. So the chances are is that the property was not developed under R1R standards. So it was developed with the platted restrictions and the deed restrictions with the county.
Okay, I guess I'd rather go with, we need to know, because where I'm going with this question is if, maybe you get the answer.
So I don't have the answer, but the applicant's representative is here, doesn't have a prepared presentation. But if the board is open to hearing from him, I will leave that to your discretion. So to answer some of these questions, but we don't have the history of the site.
Right, I guess where I'm trying to go is, so it seems like a very valid point about a fire risk. And 10 feet doesn't seem like a lot of distance for fire.
Should we hear from the applicant's
Hmm?
Hear from the applicant's rep?
Hear from what?
The applicant's representative.
Yeah, okay, that's fine. So that's what I'm just trying, my line of my question is to understand, at the time of the fire, was 10 feet all they had for the firefighters at that time? Did they have 15, did they have 20, did they have 30? So,
Hold on, we can't take.
so that's the line of my question, because that's the line of my question, understand the previous state of play.
Sure. I can't say that 10 feet is a typical side setback, or you have 5 and 5 on a side. But from a rear standpoint, I can't speak to what was on these properties previous to.
I think the board is in agreement to hear from the applicant's representative, so let's have him come up.
Please, thank you.
Can you state your name, sir?
Will Tucker?
Hey, do you solemnly swear or affirm to tell the truth in these proceedings under the penalty of perjury?
Yes. So I can answer any question you have about the property, other than maybe what was there 15 years ago. The Sweetwater original HOA Architectural Control Committee requirements were that garages were beyond, past the 30-foot rear build line that is currently in place. There are multiple houses on 77 Greensward whose detached garages are within 5 feet of the fence line. This is not really anything different than that. So a fire hazard being more or worse, there's multiple houses on 77 Greensward sharing that long fence line that are 5 feet from that. We're putting a house back that is architecturally similar to what was there previously, or what was in 1981 established as build lines.
Oh, hold on,
Okay,
hold on,
you had your turn.
hold on.
I can answer additional questions, anything that you would allow me to address with the folks that have already addressed their concerns.
So what is the architectural style of this house that you all are gonna build? What would you
It's-
describe it as?
Traditional brick home, just like the ones most of these people live in.
Okay.
As far as an eyesore would be concerned with the 29 Greensward behind, that is a problem for the homeowners association and architectural control committee, not the city of Sugar Land. This residence already has homeowner association architectural control committee approval. I believe that was attached to the submission for the permit.
It's FCCSA, not, yeah. Sorry?
As far as the 30-foot rear build line and privacy, there are no windows on the sides of the home that are within 30 feet of the back fence.
I'm sorry, can you say that again?
As far as privacy was concerned with a few of these people, no, there is no second-story window that is within 30 feet of that rear fence line. So if I was allowed to build a 30-foot, or on the 30-foot build line straight up as high as I wanted to, I have no windows back there to.
What portion of the house runs along that 5-foot setback or proposed 5-foot setback?
That is the back bedroom, and that is a single-story area. So even the back left bedroom, most of that is a single-story area. So the only portion of the house that, two-story portion of the house, all of the second floor is 30 feet from the fence line or more.
So maybe we ought to put the plot of the house, so just be sure we're all.
Correct, I can share it now.
They don't have a side view, they just have the.
We do have a side view.
Oh, do you? Okay.
That was one of the pages in here.
I didn't see it.
Put that up on the screen.
I'm sorry, excuse me, I don't mean to interrupt, and I understand that you have serious concerns, but I would ask members of the public to please not interject unless directly addressed by the board.
So that is the side elevation.
Oh, okay.
The bottom right would show the one-story portion of the home that is going towards the 5-foot bell line. That second floor window is approximately 30 feet from the fence.
And the lower bottom elevation on this drawing, that's the side closest to 81, correct?
Correct.
And did you have a plan view? Did we have that in the presentation?
That I don't know, I'm pretty sure.
Okay, there's, yeah, that's, thank you. Oh, that's close enough to the plan view. So just for understanding, on the left-hand side where the words Lot 12, Block 10, that back of the house, that's how far away?
21 feet.
Okay, that's 21 feet. And then on the right-hand side of this, after the covered, almost like a COVID patio, to the right, that's the piece that goes, and that's a bedroom there that goes back.
That's a bedroom, it's a single-story portion.
Single bedroom back to the 5-foot line there. Okay, just understanding.
So none of those windows that are near the 5 feet, they don't overlook the fence, they're all under the fence?
Correct.
Okay.
The only rear windows on the second floor would be above that covered patio section. That's 40-something feet away from the fence.
Okay. And are those windows like, what is the room those windows look into? Is it like a big living room with a high ceiling, or?
Yeah, it's high ceiling.
So there's not like people up there?
I mean, you could stand on a catwalk and look out them, but
Okay,
you're not
I see.
seeing
Right.
seeing down.
I see.
As you guys know, City of Sugar Land, you do require drainage plan submittals and underground drains, so that should satisfy any drainage concerns. And then fire code is anything under 5 feet, then goes to 1-hour fire rated walls and 2-hour fire rated walls. Anything 5 feet and more is not considered anything that has to do with fire code.
It appears there's a utility easement on the front of the property as well, facing the street. Is that correct?
No, there's, yes, a 16-foot, a 14-foot utility easement, yes.
Yes. Are there any other restrictions besides that utility easement on the front of that lot?
There's 25-foot build line and a 35-foot build line. We are behind the 35 as mandated.
Thanks.
Is the 35-foot, is that 35-foot, that's a restriction? Or is that a choice?
No, that shows up on the survey, so that is a restriction that has been recorded.
Sorry, so what's, okay, and maybe clarify the meaning of the 25 versus the 35-foot.
The 25-foot build line was old, 1980-something. At some point, the 35-foot build line was recorded and therefore is in the surveys and the title commitments.
Oh, yeah, I guess just clarifying that one, and going back to the kind of the privacy concerns, it looks like 81, when I look at that on the map, it looks like its left-hand side is right up against the fence, and same thing with 73. So the sides look like, other houses are rooted up against the side, so it doesn't seem there's anything different there.
As far as sides, everything has a 10-foot side build line, so the houses are 20 feet apart.
Yeah, okay, so those are fine. The aesthetics of the home and the proportions of the home, I don't know if I've got an opinion on that. I guess it just seems like others can look at that. I'll be honest, the one that's probably going through my mind is is the fire hazard, and what was the, setback of the previous home, if it was all the way back to the 5 foot, and the firefighters were successful in that case, well, at least protecting other buildings, not necessarily 29. That could be one thing. If that previous home had a 10, 15, 20 foot setback, and that extra space allowed the firefighters to be successful in protecting other homes, that could be, I think that could be important.
Yeah, the question, maybe the question
On
comes.
on the shared fence line that's running between all those houses, there's 10 houses. 10 out of those 14 are closer to the fence than 30 feet.
I have to ask maybe the question of,
4 or not.
of staff. I gotta believe that somewhere in city records or county records, there's an indication of what the setback was 15 years ago or prior to when 29 and 77 were, had it, previous structures built on them. Is that information accessible or not recorded anywhere?
So with that being said, so since this property was not built under the jurisdiction of the city, it was built under Fort Bend County, we would not have that information. That would be, they, filed that building permit with the county, it was reviewed under the county's regulations, so the city would not have record of that.
Is that public record?
Say one more time?
Is that a public record, available in public records?
I am not sure, potentially Lisa may be able to speak to that.
I do not know. I do not know what the county required in terms of permitting back in when that original property would have been developed. So I can't really speak to that.
Do we have the ability to call up anyone from, who spoke at the public hearing and ask them questions now? What is that? Okay, all right. I had a question for staff. Can you kind of just generally explain what goes into doing your fire safety assessment? You said you do the safety assessment, the fire portion of it. Can you just kind of give us some detail on what goes into assessing that?
Yes, so from a building standpoint, we kind of evaluate like what the applicant was stating. So again, typically per the building code, if something is closer than 5 feet, that is when typically those fire protections would kick in. So again, since this is more than 5 feet off from any adjacent structure, that did not come into play. Additionally, as well, if these two properties are 10 feet apart, we have, for example, our R1Z zoning district. That is the standard setback between properties is 10 feet. So that is something that we see throughout the city. So we did not feel like this was something that would be, egregious or anything that would be a public safety concern.
Okay. So basically, if it's 5 feet or more,
There are concerns about potential fire safety. Then you have to do fire rated walls. That would be very expensive. Then kind of like the hour of what that fire rating has to be is contingent on how close that is to an adjacent structure.
Okay. Any other questions?
And follow up to that one, there's no, doesn't include any kind of review by the fire marshal or anything like that, correct?
So no, sir, it does not.
Understood.
I guess I'll just speak, just out loud thinking. Is it in our purview to request? I mean, you've got one,
So let me clarify very quick. So the fire marshal, they do look at the building permit, but they aren't like viewing the actual special exception. So they are looped in, so we do have the fire that will review the building permit and will make sure they're in compliance with the fire code. But for this special exception application, no. So when the building permit goes to be issued, they will be a reviewer on the permit, and the permit will not be issued if there are fire concerns.
Okay, I guess okay. So I
And
guess
the
what's
permit
going,
has been issued, or?
So no, sir, so the permit cannot be issued, so this would be kind of like the precursor to
I
the
see.
permit being issued, yes,
I
sir.
see. Okay.
so what's going through my mind, just to be transparent, is we've got 5 citizens that have come forward and have some real concerns about the fire safety given the history there. And yeah, so I think you all have done a good job from a, kind of a sandbox. You've drawn the sandbox around 77, done the analysis within that. Seems fair. But I wonder if there's appropriate to ask, or can we ask for a little broader, because of these concerns and everything, is there some type of review that could be taken place that the fire marshal or something can look at in the aggregate, given the situation we have there now? What we have now, are we increasing the risk and their ability to?
I would not say so, no, sir. So in our standard zoning district, so this is R1, our standard zoning district is R1, the standard setback is 5 feet. So if you have, it's for the side yard setback, but if you say have 5 and 5, and that is accepted as the standard, so you have 10, and that is not an issue at the side setback, why would it be for the rear?
Okay, well,
So, but my understanding is we're not the final say on fire safety, right? Like after, if, say we approve
Correct.
this and they go to
So
the permitting
yes.
process, then the fire marshal gets involved and makes sure
Correct.
everything's good on the fire side.
Correct, so the different reviewers, so engineering, they'll review it for drainage, building, they'll also have, the fire rated walls if those need to come into play, fire marshal, planning, there's numerous different kind of committees and different departments that will review this to make sure that all of those concerns are addressed.
Okay.
In the image with the squares and the yellow, blue, and red, there appears to be a structure on the back of 29, right on the fence line. Do we know what that is? Just curious, and I don't mean to be snooping
No,
into
that's
people's
okay.
backyards, but
Let me-
if that's gonna be butting up on where that back bedroom is, curious to see what that structure is that's on the easement.
That's just
It's not a
that's a
structure.
concrete pad.
So that-
It's not covered.
So it's not an
Uncovered
enclosed
patio.
space, it is not an unenclosed space, it is just a slab that looks like it has some kind of like grilling equipment on
So
it.
from 29 Greensward to the closest place on 77 Greensward, the spacing between the two houses would be 35 feet.
And,
It's
and then-
14 and 21.
and then additionally, flat
can
work
say what
is
you want,
permitted
but-
to be 6 inches off from the property line.
Thanks.
I have a question. Given the general context of the neighborhood, the statement you had in there that there were 18 houses that had did not meet the 30-foot and 3 that actually had a special exemption. Was there any enumeration or a detailing of which of those properties backed up against another property that had also had a special exemption? I think one of the commenters made a similar thing, as opposed to being backed up to the golf course or a fire area.
I want to make sure I answer your question appropriately. Could you be a little bit more direct so I can make sure I'm answering correctly?
Say that again, please.
I just want to make sure that I'm providing you like a correct and clear answer. So if you could just be a little bit more concise in your question so I make sure I'm giving
All
you
right,
what I need.
I'm
Yes,
looking
ma'am.
to see, was there a count of how many of those properties that did not meet the standard or did not meet the 30-foot setback, how many of those would be directly behind another property that did not meet the 30?
So that is not something we look at. So we look at, again, the general architectural compatibility. So, okay, the standard for R1R, 30-foot rear yard setback. So literally going and measuring each individual lot and determining, okay, which are in compliance with this regulation and which are not. So those that were not in compliance with the regulation were delineated with the kind of yellow square. Then also, too, going through our ordinances, going through kind of our meetings and discerning, okay, what properties did have the special exception approved. But that layer is not kind of...
Okay. All right, thank you.
While I guess I should say that we don't have an exact number off the top of my head, we could do a little zoom around the neighborhood here, and of the ones that are highlighted, looks like maybe these two, correct, these are identified as ones that don't meet the rear 30-foot yard setback and looks, oh no, okay. It looks like they back up to one another. This one here on the corner, kind of on the curve, looks like it doesn't meet the 30-foot yard setback, and it abuts or backs up to kind of, it's on the curve, so it kind of has 2 houses that are to the rear. This one that is adjacent to the subject property looks like it is, does not meet the 30-foot rear yard setback, and it backs up to another lot or another house. Likewise on the other side, on the right side, and then these other 2 right here. So, and then there's one here at the corner. That looks like it also does not meet the 30-foot rear yard setback, and it does back up to another home. These here that are along this section look like they are along the golf course, and so that would not be similar. Looks like these 2 here on the end do back up to another lot on the side, so it's not rear to rear, it's rear to side, and then these other 2 back up along the street. kind of looks like it's about half and half. Of those that don't meet the 30-foot rear yard setback, about half back up to another lot or house, and then the other 50% back up either to a street or a golf course or open space. It's about kind of half and half.
Again, I'm sorry, I'm so sorry. I understand your concerns, but I must ask the public not to interject unless addressed by the board. I'm sorry, but the opportunity for public comment has already happened. Again, I understand your frustration, but I need you to ask you to please stop interjecting.
How come the builder gets more time to speak than the homeowners?
He's being directly questioned by the board.
All right, so I've got another question, if I may. So I look at, changing, a little bit of a tangent here, but on the FCC SA approval, it noted that, please be advised, the proposed placement of the garage will require variance approval. Can you, I guess the builder, comment on what that's all about, please?
You should have the letter that has the approval, I would assume.
Because I thought that was the garage on the
Do you have the same one I
right-hand
have?
side. Did I misunderstand that?
Do you have the same one I have that says approved at the top, highlighted in yellow?
Okay, so that's the December, so down, that double underline, halfway down. So we have, I think, if that's the December 3rd letter, we do have that. But under item number 7, as the underline, please be advised, the proposed placement of the garage will require variance approval. So is there some concern about the garage placement?
The Sweetwater guidelines state in this section that all garages should be no closer than 30 feet from the rear. This house does not have a garage that is closer than 30 feet to the fence. And so therefore they gave a variance because not all other houses have a garage that is closer than 30 feet to the fence. So the originally proposed Sweetwater guidelines said all garages would be detached and they would be at the fence. No portion of that garage could be further forward than 30 feet from the fence.
Okay, so I guess I may have missed that, why they're asking, saying that you've got to ask for a variance, because obviously something is not aligned with the code. But I guess that's not the point. We're not here to, I guess, look at the garage. Okay, I didn't know if that was going to make any, could that have any impact on the design? So I think what we're hearing, I guess what I'm hearing here is quite a bit of concern. The privacy, it seems like a lot of these houses, have second-story windows, and it sounds like there was nothing on this house that was closer than, everything was more than 30 foot away from the back line. Drainage, I heard that a few times, and I probably not so concerned about that, because I think that can be addressed with proper design and so forth. But I will admit the fire is causing me pause. I guess to me that we're lacking some information that can fully address that.
I would say about the fires, we're not the final say on that, right? Like, so even if we approve it, it still has to be reviewed by the fire marshal, and then only then will the permit be granted. That's my understanding, right?
Correct, yes, sir. It has to meet all applicable codes and
So
regulations.
it's still got to go
one
through
being
the fire
code.
marshal. He's got to look at the plans, approve it. If he feels like it's not safe, then he can deny it, and it wouldn't go through.
Yeah, I guess that would have been nice information to have, to be honest.
But
Okay.
that wouldn't happen until after we're before that process, I believe. Is that correct?
Correct.
Okay.
I'll say the thing that stands out to me, this is the fire concern, but understood we're not the final say, so totally get that. But normally these hearings are pretty quiet, and we don't get this level of engagement from neighbors in this way. And that's given me a little bit of pause. Not that the neighbors will define what gets built, but rather that that this level of engagement and concern from folks that live around the area and adjacent to the home does give me some pause.
Should we dismiss our speaker before we commence with deliberation?
Are we ready to deliberate? We're done with questions?
If there's no more information forthcoming, then I'm finished.
Unless you have questions? No? Okay, all right. All right, so the fourth criteria, we've gone through the questions and comments for the fourth criteria. So staff has examined the proposed special exception for 3 key aspects. Staff has determined that there does not appear to be any public safety issues associated with this request. Staff has not identified safety concerns as a result of the new home. Number 2, the rear yard setback comparisons. Staff has proposed that the new construction appears to be generally compatible with the neighborhood based on analysis of the surrounding area. Approximately 18 homes within the immediate area do not meet the rear yard setback requirement of 30 feet. The proposed new home is in compliance with the recorded restrictions. Under general architectural, staff has advised that the proposed new home appears to be architecturally compatible with the existing single-family residence and neighborhood. If there are no additional comments, can we have a motion for either approval or denial?
Pardon me, Mr. Chair. Yeah, if you could actually make a decision on the 4th criteria, if we could have a consensus as to whether.
All right.
May we deliberate regarding the 4th? It sounds like we're going to have a discussion.
Yes, absolutely.
Let's deliberate, ladies and gentlemen. I'll go first with y'all's permission. I want to thank all of our residents for coming in today to speak. I want to thank the owner's representative for coming in today to speak very passionately regarding their respective positions. The board has taken everything into very serious consideration, and I agree with my esteemed colleague. It is very unusual that we receive quite this degree of pushback with respect to a special exception request. I don't know that we've had this many folks come in for a request in all of the time that I've been on the board. Duly noted and appreciated. All of that having been said, I think that we should, I think that this request, the special exception request, meets criterion 4, and we should approve the request. Let me share some thoughts with you. First and foremost, almost all, if not all, of the concerns that the neighborhood residents have expressed are HOA concerns. This property and/or city building department concerns. These are not within really and truly our purview. Let me explain. Number 1, we have a letter from the HOA, including the architectural committee, that has approved the construction of this property in accordance with the plans provided to us. The residents here I don't know whether or not they have initially brought their concerns to the HOA or even knew about these requests, but the HOA represents the neighborhood's interest vis-a-vis the size and shape of the home. And I understand that the residents who have come in today are very upset about that, and they voice concerns with respect to public safety, with respect to architectural design, that the home is ugly and doesn't match the rest of the neighborhood, with respect to privacy, with respect to visibility. I'm not suggesting that these concerns are purely speculative. What I am suggesting is that these are HOA issues, guys. These are not zoning board of adjustment issues, and it's not within our purview to preempt or second guess what the HOA that represents these folks' interests that they pay dues to has decided here. Second off, I think that city staff has done an exemplary job, as always, with respect to addressing all of the issues pertaining to criterion 4. They've conducted a public safety review. They've looked at the proposal and the neighborhood, including rear yard setback comparison. Notably, approximately 18 homes within the immediate area don't meet the setback requirement of 30 feet, and we have approved at least 3 special exceptions in the immediate vicinity. I'm not comfortable proceeding otherwise with respect to this property. There's nothing unique about this property relative to those existing or with respect to which we have approved special exceptions. I know some might contend that foolish consistency is the hobgoblin of little minds. I don't think that rule pertains here. I think that we need to do what we've previously done and leave it to either the HOA and/or the city building department to address some of the other possibly speculative issues that the neighborhood residents have raised. Finally, proposal on the neighborhood general architectural, I think that we've spoken to. These issues, in my mind, have been adequately disposed of by staff, by the HOA, and ultimately will be reevaluated in surgical detail by the city building department, whom we know and trust. And on those grounds, I would suggest to my fellow board members that we approve this request.
Does anyone else have anything to say?
I think what I would, thank you, well put. I think my concern, quite honestly, is in isolation again, looking at 77, I agree with all those comments. What is missing for me, maybe it's outside our purview, maybe it's not, is the broader context. Often we sometimes get short-sighted, look at things just in the sandbox, and sometimes we don't take a step back and look at the broader context. And, if 77 was the first one being built here, it'd probably be fine. But you've got other things around it, you've got the broader context, and that's what's causing me to kind of say, I wish we could have a little more view on that, and that's what's given me pause. These things could be addressed, or again, maybe they could be taken away and be examined a little more closely and whatnot. I don't know if that's in our purview to request that or not, but I guess when I hear that and all these comments and look at the broader context, I don't know that I could answer number 4 in the affirmative.
Okay.
So that's where I'm coming from.
Couple of questions. One, we have to decide based on what's in front of us right now, correct? Yes. Okay. And then number 2, we can consider safety, architecture, all that are factors that we can weigh, correct?
Yes, absolutely.
Okay, all right. I saw 2 main concerns. One is the style of the home, that it's going to go right up on the fence. It's going to look ugly compared to the rest of the homes in the neighborhood. There's going to be privacy concerns. When the builder talked about the elevation of the portion of the home that's closest to the fence, it's going to be below the fence line, the windows. So I'm not as worried about privacy, because it seems like the second-story window that faces the back is going to be further back. It's a high-ceiling living room. So
There's still some on the side, but they're just more than 30 foot back.
yeah, they're far enough back.
Well, their side and,
Yeah. So, and then the second thing, obviously the big thing is the fire, right? You all had a fire in your neighborhood, and I can understand once that happens that you're deathly afraid it's going to happen again. We're not experts in that area, and I feel kind of reassured knowing that if we approve this, we're not the final say in that. The fire marshal, who is the expert in that area, is going to come in, he's going to examine the plans, and if he feels, I'm assuming it's a he, I'm sorry, if he feels that it is safe in terms of fire concerns, he will approve it, and if he feels it's not, he will not approve it. So based on that, knowing that it's going to go through that next step, I feel okay letting it go through this step and let it get to that next step, where someone who has an expertise in that area can really judge it,
I wouldn't be comfortable, I wouldn't be comfortable with us effectively usurping the authority of either the HOA's architectural committee, which has examined this, nor would I be comfortable usurping the authority or pretending to the expertise of the fire marshal. I mean, we have experts in charge of both of those areas, and it's not us.
I wouldn't argue that or at least I wouldn't be qualified to make either of those determinations, but I guess the part that I'd like to understand, maybe it's too late for the question, is this the only opportunity for citizens nearby to have raised their concern about this this construction? And maybe that goes beyond, our set of responsibility, but just understanding if they're in the permitting process and on the way through, final construction, et cetera. Is this the only opportunity for citizens to express concern? I don't know that.
I don't know if staff can answer that.
I can address that, yes. So yes, this would be the last public process that folks could be a part of. If this were to be approved, it's a very administrative process through the building permit phase of the project. Again, there are codes that various staff from various departments are measuring and analyzing and comparing the proposed against, and our role is to ensure that it meets those, and there's not subjectivity to it. does it meet or does it not meet? And if it does, it's approved. If it doesn't, it's either comments and the opportunity to, goes back to the applicant to address it to meet the minimum in order to get it approved. So it's a very, from this point on, it would be administratively reviewed.
Or rather, understood in that this is the last stop for citizens to voice concern.
Mhm.
Is this the first stop?
Correct, yes. So at this point, it would be what we would have received or is a building permit application. It is, what is being proposed is showing that it doesn't meet the zoning requirements. However, they do qualify for the special exception, and so that's how it got here. Everything up until this point has been at the staff level, and if it were to have met the zoning requirements, it would have been approved.
Right.
But because they are wanting a special exception to use the recorded restrictions that apply to this neighborhood, this is the process to come to before this board to request the use of those prior recorded restrictions versus the zoning restrictions that are on the property.
Understood. Thank you.
Okay, so I'll ask the board again on the fourth criteria. Do we believe it's? I'm sorry.
I'm sorry, there's still a hesitation here for me. Having served with homeowners associations, there's a lot of dependence on the regulatory environment for them to make their decisions, because they're talking about their neighbors, right? And while I understand, and I agree to a point with your statements, I think in this point, a homeowners association would expect us to give a clear direction, and I'm not comfortable with a clear direction right now. It's like I need more information about the fire marshal side of things, the fire side of things, so.
The fire marshal won't be in a position, the building department and the fire marshal aren't going to weigh in until after we make a determination as to what they can and can't build. So I recognize there's a chicken and egg problem there. We're just not going to have that kind of certainty in producing a decision here. We're going to have to proceed with the limited information available.
Yeah,
I mean,
I understand that. I can make a vote, but it's if that's the question, yes, I could make a vote right now, so.
Fair enough.
Okay, so is there any more comments or no? Okay, so so who feels it meets the fourth criteria? Oh, I'm sorry.
Actually, I was going to make a recommendation.
Yeah.
I would suggest, why don't you go ahead and make the motion? If the motion passes, then clearly you have found that
Okay.
the criteria is met. If the motion fails, you will have found that it's not met.
Sure. Okay, so do I have anyone for a motion to approve or deny? Mr. Morton?
Thank you. I move that the special exception be approved, subject to the condition that the proposed single-family residence is constructed in accordance with the attached site plan and elevations.
Do I have a second? I second. Yeah, let's take a vote. Okay, the motion has failed. Nothing else? We can adjourn?
Yeah, the motion is denied.
Yeah, motion is denied.
Or, sorry, the special exception.
Special exception is denied. Okay, so item 4, do we have a motion to adjourn the meeting?
Motion to adjourn.
Have a second?
A second.
Okay, all those who approve, raise your hand. Okay, the meeting is adjourned.